was showing Bravo. One time, man.
Yeah, just a second. I think it's
following her around. Pilot, somebody who's going to write a pilot for the WB network, for a show produced by Aaron Stellan, with a character based on me.
so that box is still up.
It's somebody with like a notepad is following her around.
No, it has the same thing as the main screen
yes.
now.
Yes, sort of. We were.
Do I just close this?
I mean, we worked together very closely for 10 years, and then we just got professionally worked. I can't know the craziness anymore. So interesting story is Dan Graham was actually hired
because it has like a sub screen now where I pushed all that. And is there something else in there, or do I go back to the main screen?
I can't take this anymore. You gotta respect that.
She drove her beating up.
Yeah.
Not so bad.
Oh, you mean all the way at the bottom? But it's still, one says Zoom cloud meetings, and one says Zoom meetings.
So we were, when you guys were in 2 unions, we were in 1 union, like we're in and
Oh, yeah, one said, yeah, one just says Zoom meeting. And then this, well, yeah, it shows like, you know, like where Judge Dixon is sitting here.
Don't go to the gym a lot, and every time you go to the gym, you see the same person there, you assume that.
I think that does. So it has a big screen, and then up above on the bar, it has like me sitting where, okay, so that's good.
Yeah. Okay. So probably we're after.
So,
Oh, yeah, very nice.
I just laughed, so is that good then? Okay.
If I was there, she was there. Or maybe it was just coincidence, I don't know.
Okay, thank you.
That's why I say. I don't like try that. He was kind of fun to.
Actually, I know for a fact, Mike, that he liked you too.
Yeah, no,
You know who you did not like?
Oh, they did, yeah.
Passionate. It's just like, I don't know, this guy loves this.
What was that, Ray?
Oh, yeah, no, you're not sleeping at night, you know.
Think you can pause on?
Yeah.
Well, it was beautiful too.
Oh, no, yeah.
They needed each other. I don't even know how it got so bad.
I have no idea.
Yeah.
Well, I just said, I really don't mind it. What's wrong with you? Yeah.
Well, I just remember,
What you see?
I remember we had this trial in it was such a great place. Yeah, McDermott's like yelling, you know.
Oh, yeah, we went to California to do an episode of this. It was Polygraphs.
Oh, yeah, I remember that.
Anyway, so we did that position, and somebody, the three of us, was hung out.
You tried the freeze?
No, we crossed the streets.
Oh, really?
Yeah, so they had a little conventional. I just can't stand John Fry. It's just like, it's unusual. Then you maybe have a group therapy session or something.
What was Father Simpson doing?
No, it's not just a bed.
Oh, it was just you and Cosmo.
And the ex-priest who was the pastor.
Oh, I
became church where Father was. So Jim and I were flying back out of Orange County or something. So we had a couple hours.
You guys just like having cocktails?
Yeah, and they said like, well, you know, if you want to go to the airport for a couple hours, why don't you just go out on my patio and I'll have a drink?
Okay.
That's a great position.
Yeah, it's like, I've not done this before, but it sounds more interesting than to sit at, John Wayne Airport waiting for my flight.
Do you have any gaps in your memory that afternoon?
Yeah.
Does Tim?
But I remember the preschool, he gets on the preschool to get married. And we were embarrassed about that. It's just like, so many other reasons why you would have left the preschool that are actually embarrassing.
Right.
Yeah.
That's.
You don't need to worry about
You
this.
should be good about that. So the newest thing Mike has done. So he came out of retirement, quote unquote, and he puts up
That's
this
not allowed.
housing firms, and they spend tens of millions of dollars on PDF typing, and they come up 20,000 voice cases. And it's a driving force in the voice that bankruptcy. And then always the case with Cotton, he has a just a dramatic split with whoever he's partnering with. And so he has a split. So are you on Twitter? I'm not.
Yeah.
Now the Kazan is doing on Twitter is insulting his like every day. They're and I just want to talk to the guy's name is Ken Rothweiler. Nobody knows that Ken Rothweiler has been sued 3 times for medical or legal malpractice. These are the facts. He was disciplined by the Pennsylvania bar. Yeah, it's all playing out in the public forum.
If I see Tom again, I'll let him know. My Christmas gift to you is a massive amount. It's the best gift I've ever gotten.
Tell Tom you on Twitter.
Yeah.
Yes.
What if we start yet?
Thanks. That's really helpful.
All rise. Court is in session.
Please be seated. Thank you. Before the court invites Mr. Levison to continue cross-examination of the witness.
Thank you, Your Honor. That's my understanding. We're going for 1 more hour.
Yeah, I was just going to mention that. Thanks. I'm good until about 3 o'clock, but no later than 3. And then tomorrow, I'm good to go. So, but invite some input from the parties tomorrow at what time they want to quit for the day, taking into consideration their travel times and preferences. But I'm good all day tomorrow. So food for thought. Just let me know tomorrow morning when you want to quit. Okay.
Thank you.
Okay.
Mr. Polizia, thank you again for being here. Picking up where I left off, I didn't talk about damages issue for SA, the admitted liability. Not in terms of money, but in terms of impact on his life. What were your thoughts about his damage? How he was impacted and damaged?
Oh, I was concerned that there would be a significant case made for impact damages based on the type and the extent of sexual abuse he had.
Okay. And in what way? Can you unpack that for us?
Well, the primary damages claimed were emotional distress, and it's difficult to articulate. I mean, in most of these cases, you see plaintiffs who are adults who are abused as children, and so they're better to articulate the damages about damage to their relationships, damage to their belief systems when, for example, a church is a defendant, damage to their sexual lives, things of that sort. With a 5-year-old who's plaintiff, they're not really able to articulate that, and whatever damages there are, they would be somewhat speculative, and it would be complicated by issues with respect to child rearing and issues in the home. So again, it's really hard to articulate damages for a child of that age. My concern is that a jury, given his age and given the abuse that occurred, would basically just presume that he's significantly damaged by the abuse.
Okay. During your investigation, were there any signs of that damage?
I don't believe that at that time he was, attending counseling or anything of that sort. So and at this point, I'm sorry, I don't recall any specifics from his file.
Okay. Were there any about economic damage for SA? Say he wasn't going to counsel. Were there any other economic damage?
I don't recall that there were.
I should ask for past.
I don't recall that they're seeing any evidence of like lost wages or lost earning capacity or anything like that, which would be unusual for a child of that age. You do get those claims more often where there are adults who have a demonstrated work history, and I remember seeing one saying like, I was a laborer, but without the abuse, I would have been a dentist. So they have something to say, and so you owe me for these lost wages based on the damage to my earning potential. With a 5-year-old, I think it would be mostly about emotional distress.
Okay. You mentioned something this morning about having a memory for a 2-year-old. Do you remember what the age was of
He was in kindergarten when the disclosure was made, and the abuse had been going on for, I know, at least 4 months at that point. So between ages 4 and 5, probably closer to 5.
Okay, so that was a standout case. That was a standout case.
Yes, I agree with that.
And that's why you recommended a higher settlement value for that case.
Yes. The
last one was 8K. We hadn't covered 8K yet. But what did you think about the what were some of the liability issues or in your favor at trial? If you had gone to trial.
From my memory, when the mother first came forward, she was basing the claim not on any disclosures, but on behavioral issues. And then she was told by the CPS people that wasn't reliable evidence that a child had been abused. And then after that, then she started to say that her child had made disclosures, for example, that Eli scratched inside his anus. And there was a process that they went through with respect to her, but there were very suspicious aspects of that claim and whether that disclosure was legitimate or not. And if I remember correctly, I think she also had some criminal convictions for crimes like fraud. So also with respect to the interviews of the notes, at one point, he was Junior was in Eli Tabor's class, but it appeared that Eli Tabor wanted nothing to do with the child, even on a social or caregiver type basis. That for some reason he developed sort of an antipathy towards Junior, did not want to have anything to do with him.
Okay, that was based on things that were being said by other co-workers at the learning center?
Yes, I remember references to that in Peter Altman's notes, and there may have been references to that in the CPS investigation file too.
Okay. Was AK himself interviewed and asked whether or not he was subsequent to when she said that he had made disclosures, and then a forensic like interview was done of him, and that in that interview he made no disclosures. Okay, and again, this is a claim that came up for the first time after Eli Tabor had been arrested and confessed.
Yes.
Okay. Eli ever confessed to abusing AK?
No, to my knowledge, to date, the only two that he's ever confessed to are SA and ND. I'm not aware of any others other than that.
Okay. We went over this last time, but just to recap real quickly on your education and work experience at the University of Michigan and Boston University Law School.
No, I went to the University of Michigan and for undergraduate. I started at Boston University as a freshman, and I went to New York University for law school.
I see. Okay, thank you. And you clerked for U.S. District Court. Where was that again?
Eastern District of Missouri, which is St. Louis.
Okay, and then you worked for 2 years at Perkins Coie in Seattle, and then about 16 years at Stafford Fry. Correct.
Correct.
You worked with Dan Bremer, and that's where you started working.
I'm sorry. 16 years at Stafford Fry, correct. And you worked with something.
Worked with Dan Bremner, I think is what the question is.
Oh, I'm sorry. I'll try to say that. And then you worked at Stafford Fry, and you worked with Dan Bremner. And that's where you first were introduced to working on these molestation cases.
No, I actually worked also with an attorney there named Tom Fry, and I actually began working on these cases with him.
Okay. And then you were there at Stafford Fry for 16 years.
17.
17 years. And then Summit Law Group since then, for about the last 10 or 11 years.
Yeah, a little over 10 years.
Okay. So you mentioned that you had first chaired one trial in a molestation case.
Yes.
And how many other trials did you participate in?
Of any type?
No, I'm just focused on the molestation cases. I'm sorry.
3.
3?
Yes.
And how many other cases did you work on? So
I never counted.
can you give us a range?
I did it for about 20 years and probably four to five files per year. So maybe 80 to 100 cases. I should say 80 to 100 claims, because some of them were consolidated into one complaint like we have here.
Okay, how many cases overall, any kind of case, did you work on where the assignment came from Philadelphia indemnity insurance?
I can think of 4. Actually, 3. And Philadelphia was involved in the other, but they actually retained David Russell for their part of the case. So 3.
Was that before or after this case?
That one was after this case. That was the second HMH versus Gateways case.
Okay. Did Philadelphia ever indicate that they were unhappy with the work you did on this case?
No, not to me.
Are you aware of them complaining to anybody?
Not currently. I don't have a memory of that currently.
Okay. Tell me about your experience with settlements and molestation cases with kids.
And so, are you saying when the plaintiffs were children?
Yes.
Like
Plaintiffs were children.
when the abuse occurred when they were children, or when the plaintiffs were still children?
Well, maybe you could break it down for us, but in cases similar to this, you mentioned us, have you handled other cases over those 20 years that you had analogous cases?
I can only recall one other case that involved young children. But that it was basically a lawsuit where I was representing the great grandfather who had molested his great grandchildren, and they were very young, in the ranges of like between 2 and 5 when the lawsuit was brought.
What was the outcome of that case?
We settled.
Do you remember the range?
I don't, but I do remember the great grandfather was in prison and probably would be for the rest of his life. And his position was, this was a very easy settlement. His position was, if my children and my grandchildren want all the money to skip 2 generations, then the great grandchildren can have it. So that was his position on settlement.
Okay. And so what was the case settled for?
I don't remember. I mean, his estate was, I think it was worth over $1 million. He had a house on Magnolia that was a primary asset.
Okay. I'd like to put up the budget that we looked at earlier. It said that 116. Couple of questions about this. Number one, on the other cases you worked on in Philadelphia, were you asked to do budget?
I don't remember. I may have been.
Okay. Do you remember ever getting a response from any insurance company when you submitted a budget and they disapproved it?
No.
Do you remember ever getting an approval, a response when you put your budget?
Possibly. I work for an insurance company named Guide One, and I think I did budgets for them, and I may have gotten sort of an email that said your budget has been approved, something like that.
Okay. Do you expect to get approvals every time you submit a budget to an insurance company?
Yes. I don't know how closely they're scrutinized.
Yes, you'd expect them to come back and tell you if they're approved or not?
No, I said I do. My expectation is that whatever I submit will be approved, and I don't know how closely they're actually scrutinized. It may be just something that they need to have for their file, and then they accept it.
You asked questions about whether or not Philadelphia ever approved your budget. You didn't get a response on this particular budget, correct?
I don't remember. I'm sorry. I don't remember whether that I got an email or I doubt that I got a call about that, but I just don't recall whether I did or not.
Was that ever an issue, approval or disapproval of the budget in this case?
No, I don't remember it coming up after I submitted it. I don't remember it coming up again between us.
Okay, so breaking this down a little bit, we've got up here interrogatories. You only have 10 hours. Is that for drafting interrogatories?
I'm having a little trouble actually seeing this,
Bigger?
and my exhibit books disappeared. Oh, that's more helpful. If it says interrogatories, it would be, I guess it would include drafting interrogatories as well as answering them.
Okay, was this in all the cases or just some of the cases?
This budget, I believe, is for Steele Barbieri.
Okay, and was the budget made when you were defending only the Learning Center or when Mr. Olson and Mrs. Big were joined to the lawsuit? Or sued separately?
Based on when I think this was created, and again, I'm relying on my memory from this morning, I think all six claims were pending at the time.
Okay, and did you draft interrogatories?
Yes.
And you responded to interrogatories?
Yes.
Did you do it in 10 hours or did it take longer?
I have no idea. I mean, looking at that number now, that seems a bit low.
Did Philadelphia ever challenge any of your submissions? Did you get, by the end of the day, were you paid for all the work you did?
Yes, ultimately, I believe I was.
Okay. Then you have non-expert depositions. You've got 20 depositions. Does that include depositions that were noted by the opponents?
I believe so. I think that's the only place that there would be that category.
Okay. I'm talking about depositions. In this case, there were police reports, there were CPS reports, there were other expert reports, there were forensic reports you mentioned this morning that were interviews in jail. Did you feel like you had to note depositions of any of the people that were at the Learning Center, that worked at the Learning Center?
All right. I mean, through interviews and the investigations, I believed I had a pretty good idea of what they had to say. But I also think it would be a prudent practice to put them under oath and take their deposition. But I had from the investigations that had taken place, I had, say, a much better idea of everyone's observations and testimony than I would in a normal case.
And have you interviewed the people at the Learning Center?
I interviewed some. Peter Altman interviewed more of them. And for some reason, I believe that Mary Sarah Goomba, who was my paralegal at the time, also did some interviews, but I don't remember any details about that.
Remember how many times you went down to meet with people down at the Learning Center?
I don't have a precise number, but I was probably down over the course of the year down there maybe 15 or 20 times for various reasons.
Okay.
Actually, the Learning Center itself was only open for a couple months. So I would say that while it was open, I was probably there 5 or 6 times. The other times I went down there were to meet with people in the Olympia area, but not at the Learning Center.
Okay. Did you feel like you still needed to depose those people after interviewing them to be prepared for trial?
I mean, the thing is, no, I could prepare for trial without deposing them, but it is also a prudent practice to do so.
Okay. How about experts? Did you retain any experts?
Initially, we contacted experts and spoke to them about their willingness to participate as experts. But I don't believe I paid any expert retainer fees.
Okay. What experts, remember the names of the experts? What the subject matter was?
Sitting here today, I don't. I do know that there are exhibits about that.
There are what?
There are exhibits that have expert disclosures.
Okay. Do you remember how many experts you had on your expert disclosures?
Maybe 3 or 4.
Okay. Do you remember what they were gonna, what the subject matter is?
One of them may have been basically the standard of care for running an early learning center.
Okay.
I'm sorry, I'm blanking on the others.
It's been over 10 years, so I don't expect you to remember everything. You've done a pretty good job so far. All right. Did you receive expert reports from the plaintiffs in this case?
Only the one, sorry, from Matt Logan. I didn't receive any other expert reports.
Okay. Did you see any need to depose him prior to trial?
His expert report was pretty explicit about what his opinions were. Again, it would be a prudent practice to do it.
And his opinions had to do with what? Do you remember?
They had to do with, basically it was a psychological evaluation of Eli Tabor. And he cribbed, my memory is he cribbed quite a bit from the Sue Batson report. So he was opining about Eli Tabor's basically like psychosexual history.
Okay, were there any, did you receive any other expert reports from the plaintiffs? Had to do with the plaintiffs or the plaintiff's damages?
No.
The production of documents, you had 25 hours there. You responded to production of documents, correct?
Yes, actually, when we did the consent judgments, we were actually still in the process of responding to production. That number is actually way too low because there were a lot of documents on the OELC's computer system that needed to be basically accessed and reviewed and produced, and that was still in process even in September of 2012. So that number is probably would deserve to be a lot higher than that.
Okay, you're still producing documents a month before the first trial.
Yes.
And if we scroll down, expert support, what's that? On the bottom line. You gotta see it on this thing.
Well, I understand IME. I'm not sure what the others are. Again, this was a form. Oh, I guess recon would probably be some kind of surveillance if you put somebody under surveillance.
Number 3 and 25 hours. Do you remember? If you remember, what was that for? Maybe not.
I'm not sure. I mean, it could overlap with experts, for example, to have an independent medical exam done of the plaintiffs.
Okay, and then associate attorney assistant, 400 hours. What was that for?
That would be for basically for Peter Altman, who was we are a members only firm, so we don't have associates, except he was essentially an associate, and Mary Saragumba, who's acting both as a paralegal and a legal assistant.
Okay, and what kind of stuff do they do?
Peter was, I know both of them I believe, were interviewing witnesses. Peter was assisting me in things like answering the complaints, answering interrogatories. Mary Saragumba was assisting me in answering interrogatories. She was, sorry, too quick?
Yes, especially with names I'm not familiar with. Saragumba?
Saragumba,
Gumba?
Sarigumba.
I'm sorry, start over.
Sarigumba. Mary was taking the lead with respect to the document production and coordinating with the basic forensic expert about accessing the documents and producing them.
Okay. Response to pleadings, 3 hours. What is that?
That would be answering the complaints.
Okay. Does that seem a little low?
No, the complaints were pretty basic and straightforward. So they may have been, 3 or 4 pages each.
Okay. Communication with court, opposing counsel, insured, and witnesses. 150 hours. Is that your time?
That would be my time as well as Peter's and Mary's time.
Okay. Let's go on. We have expenses, pretrial motions for summary judgment. You didn't need to bring any motions for summary judgment, did you?
I did not think that they would be successful.
Okay. Did anybody at Philadelphia ever tell you you should not bring a motion for summary judgment?
No. There was an email exchange between Jackie Holloman and I where we discuss motions for summary judgment, and I tell her about this new Court of Appeals case that just came out, and that my view was dim about summary judgment motions, and this case made it dimmer.
Okay. Who made the ultimate decision whether or not to bring that motion?
Me.
Okay. Motions eliminated. I don't think you got that far, did you?
I know that Peter was working on motions in limine when we went the consent judgment route.
Okay. Do you remember where you were in that process?
I don't.
Okay. Trial preparation, 100 hours. So what's that include?
That would include the trial brief, the jury instructions. It would normally include motions in limine, but they have their own separate category. And then it would include preparing witnesses, directs, and crosses.
Is that include a time fee? There's at the end of that.
Me and Peter and Mary.
Okay. So if you were to divide that up between the 3 of you, if the case had not settled a month before trial, if you have enough time to work that 100 hours between the 3 of you to get the case ready for trial.
I'm sorry, I don't understand the question.
With a month left to go to trial, at the time you settled, if the case had not settled,
Mhm.
you feel like you had enough time to get the case ready for trial within that month.
Well, not ideally. But would we have pulled it together? Yes. But ideally, we would have had more time to prepare for discovery and for trial prep at that point.
I'm sorry, time to prepare for discovery and
Trial prep at that point.
While we're on that topic, did you ever discuss with clients or their personal counsel anything about your preparedness or lack of preparedness, or the status or posture of the case with respect to readiness before or at the time you entered into the client?
Not that I can recall.
Okay. So if you didn't tell them about it, it could have played any role in their decision one way or the other whether or not to accept the settlement. Would you agree?
Well, I did not discuss it with them. They did not discuss it with me. So I don't believe it played any role. The focus from them was, basically ending it without any risk of financial consequence to themselves. And that's essentially what we discussed as being the benefit of the consent judgment.
Okay. Did they ever ask you a question? Did they ever ask you, any of those people, the clients or their personal attorneys, did they ever ask you what happens if we take the case to trial and we're ready to go? What are our chances of winning, anything like that?
We did discuss basically problems with liability. That is something that we discussed.
Okay.
And we did not discuss about trial readiness. We did discuss some problems with liability if the case were to go to trial.
Okay. Trial readiness was, in your mind, not a factor at all in entering into governing judgment. So,
Yeah, I just got to object to the kind of the testimony coming from counsel, because I think it's inappropriate, particularly given the fact that Mr. Morosino was hired and retained by Philadelphia.
Well, it's a leading question, so the objection is sustained as to the form of the question, but you can rephrase it, Mr. Reverson.
thank you. Well, I think I was just summarizing what you had already said, but as far as you knew, was readiness ever a factor in the decision made by the clients, the advice of yourself to some extent, mostly the personal counsel, and entering into the covenant judgment?
Jack is asking for speculation.
That's completely where.
Overruled.
It was not something that I discussed with them or that they discussed with me. So it just wasn't something on the table at the time.
Okay. Now, at the time of the settlement, there was one trial coming up in a month and then another one 2 weeks later,
Yes,
and then another one 2 weeks later than that,
correct.
and then another one months later, April of the following year, correct?
Right. The trial against the individual defendants,
Yeah.
I think that started in the spring, maybe April of 2013. Yes.
Okay.
And I don't remember if because there's 3 cases against the individual defendants. I don't remember if they all had the same trial date or different ones.
Okay. So the first 3 trials would have been only against the Learning Center. Am I understanding that correctly?
That the Learning Center was the sole defendant in the trials scheduled for the fall of 2012.
Okay, and at the time you settled the case, and there's a lot of discussion about assets there in the documents in this case, but what's your understanding of what their ability to pay in excess judgment would have been? What assets did they have?
Well, OELC was basically a defunct local daycare. But after they went out of business, they sold the West Side facility, and I think they had about $300,000 as a result of that sale that the board was holding. For what reason, I don't know.
That's the only asset you knew about at the time.
For OELC, I believe that's the only asset that existed. Because I actually talked to John Masterson about that, and that's what he told me.
Okay, so even if those 3 cases had gone poorly, the most that the plaintiffs would have received was whatever the policy limit was, plus $300,000.
I'm going to check again.
Sustained.
What would have been the worst case scenario financially for the learning center client. Has there been a judgment of
That they would lose up to the $300,000 that they had as assets.
Assuming they got to keep that money, what were they planning to do with it?
I have no idea.
And then you had to go April to prepare the cases against the individual.
Yes.
Would you have been better prepared to go to trial in April to protect their interests?
Journal, speculation.
Overall,
Yes.
The discovery cutoff date come and gone.
I don't believe so.
And that, you're talking about the individual, the cases against the individual.
I have not actually, there are case scheduling orders for those cases, and I don't know what they say, but I don't believe so.
Okay. And you would have had a chance to see how the cases went on the first stage before you decided how to defend, or whether to settle, or what to do to protect the client's interest by the time you got to April the following year.
Yes, I would have had a lot of input from how the first sets of trials went. I've never encountered anything like that before, but I also couldn't imagine how we would try some cases and that those cases against the two individual defendants would still actually go.
Okay. There was a status conference with the judge in the first few cases sometime a month or so before trial date. Remember that?
Yeah, actually, I saw that in the exhibit book, the transcript of that.
Okay. And what did that judge say about mediation?
My memory is that he said he called the case a month before trial and asked me if we'd actually gone to mediation yet. And I said no, and he said no trial without mediation. That's my memory.
Okay. You believe that he would have enforced that?
I took him at his word. So yes.
Okay. So you didn't, at the time you settled the case, or actually at the time of that hearing, you didn't think the case was going to trial before you got a chance to mediate. Correct? I
didn't, but also I recall that the consent judgments were well in process at that point in time. So, and from what Judge McPhee said, that this was a necessary step prior to going to trial. And I've heard that before from other judges as well. So it wasn't news or a surprise to me.
If you hadn't, if your clients had not entered into that settlement agreement, would you believe that you would have more time to prepare for trial, that they would not have taken place as scheduled?
Well, I was hopeful that would be true. But the thing is that I'm not in control of when something goes to trial and when it doesn't. So it would be up to Judge McPhee to basically deliver on his statement that no trial date unless you've gone to mediation first.
Okay. You said Judge McPhee said to you, were you the only one there at that hearing? That conference?
Yes. I mean, of the counsel, Mr. Cochran was in trial in Olympia on another matter that morning.
Yes, you were there alone.
Yes.
On this case.
Yes.
Did you retain an expert named McGovern?
That name sounds familiar. And I do think that Peter had interactions with him.
Okay.
Sure, I just want to make sure the record's clear that that's not a retention if you haven't paid money. I just want to make sure that the record's not used like that.
You can ask the witness on cross-examination.
Thank you. Let's put up the
redirect examination. I apologize. And I apologize for interrupting you, Mr. Lavison.
February 5th. What? You recognize this letter, Mr. Lavison?
Yes.
What is it?
This is the letter that I wrote to Jackie Holloman, February 21st, 2012, regarding my opinions and thoughts and facts regarding the case.
Okay, so February is about 6-7 months before trial.
9?
9 months before the scheduled trial.
I think it was about 9.
Okay. And so in this letter, start out and is this your first major report to Philadelphia?
Yes.
Did you send copies of this report to the clients?
I don't recall.
You go through here and you talk about the factual background. You scroll down a little bit here. So in this area here, we're talking about Eli was hired as a substitute teacher at first for 2008. And he had a relative that already worked at the learning center.
His mother was the site manager at the downtown location for a time.
Okay, was she ever involved in the hiring process?
She said she was not.
Okay, was there any evidence that she was?
Not that I saw.
Was there any evidence that she influenced the hiring decision?
Not that I saw.
And you talked about in the middle of that paragraph, you talked about a background check. Has the Learning Center done a background check on Mr. David?
Yes.
And how was that done?
It came out with no concerns. It didn't pull up anything that would justify not hiring him.
Okay. Then in the next paragraph, you talk about disciplinary issues that Eli Jeter had while he was working at the Learning Center. And you say there were 10 of them. Did any of them have anything to do with molestation issues? Or anything that would be a red flag with respect to causing any concern on the part of the Learning Center that you might molest somebody?
I want to check the compound question.
It is a compound question, so the objection is sustained, but you can rephrase it, Mr. Lavison.
Thank you, Your Honor. Anything in those 10 disciplinary warnings that had anything to do with his eventual molestation problem?
The ones that, and I don't specifically remember what all of these were about, but my recall is that the 10 that I'm referencing there do not. They don't have anything to do with his relationship with SA. They are other issues about basically lack of discipline and lack of emotional control.
Okay. Well, later on, there would be a couple of concerns with respect to SA. Is that correct?
Yes.
Okay. One was just among the lips.
There was that disciplinary memo, and that's improperly dated. It's an unsigned 2010 reprimand. Yes, for lying on the ground with him and kissing him on the lips.
Is that one incident or two?
No, that refers to one incident.
Okay. Okay. And if the we scroll down some further down. In the fall of 2010 is when Tabor moved in with the family where SA lived there.
Yes,
They were there for about 4 months.
correct.
And and then was found at home on January 12th, 2011. And that's when he got caught.
Yes.
Right. Keep scrolling down, please. Keep going. Okay, and here's talking about, we talked about a little earlier where Mrs. Bergdahl called CPS, but maybe a day or two late.
It was, yes, it was beyond the 48 hours. And I don't recall how much beyond, but it was beyond 48 hours.
Are you concerned about that delay in terms of the liability?
No, that there were two findings against her, and I wasn't concerned about this one. I was concerned about the other.
What was the other?
The other was basically during the CPS investigation, there were a lot of teachers that came forward and said that they had complained to Rose about their suspicions of an inappropriate relationship between SA and Eli Tabor. And those allegations were of, much more concern to me with respect to negligence and a finding of liability.
Who, the offense, that offense, was that the teachers, was that the school, or was that this Bergdahl?
I'm sorry?
Was that second problem that you talked about, the second violation, who was that directed?
From CPS's perspective, it was directed at Rose Horgdahl, and the finding was against her, which was a little mysterious to me, because teachers are mandatory reporters as well, and if they have these suspicions, their obligation was not to tell Rose Horgdahl. Their obligation was to call CPS or law enforcement, same as hers. And for some reason, none of them actually got findings, even though they said that we had suspicions and we told Rose Horgdahl. In the end, though, it all was basically, not positive facts for purposes of a liability finding.
All right, if we can scroll down a little bit more. Here's some discussion of the polygraph test that we already talked about in the reporting to Philadelphia. What about the results of the polygraph test?
Oh, that as part of Sue Baston's evaluation, he took a polygraph, and he, according to the polygrapher, credibly denied having other victims other than SA and ND.
You say he credibly denied?
According to the polygrapher, yes. When he denied having other victims besides these two, the polygrapher said that he registered as credible.
Okay. And then there's something in there about, according to the teachers, he particularly liked interested girls. Why are you reporting that?
This primarily comes from Peter Altman's interviews and my interviews as well, is that he did not seem, and they commented that even SA's sister was of absolutely no interest to him. And then after he began having this inappropriate sexual relationship or unlawful sexual relationship with SA, he seemed to be focused on him almost exclusively.
Okay, let's keep going down, please. Keep going. We talked about this. Keep going. Okay. And here, you're now going through each victim as part of your reporting, and if we're talking about And this, we've already talked, I'm not gonna spend a lot of time on this, because we talked about it this morning, but here you're reporting to Philadelphia that, CPS investigated both of the EI and looked at the allegations of unfounded. Correct?
Yes.
Okay. In this paragraph, we're reporting that the CPS investigator developed the opinion that the skills were secretive and paranoid. Why did we say that?
I found information about that in the CPS investigation file and also in the law enforcement investigation file. And I just thought it was relevant.
Why was it?
Hmm?
Why?
Well, I guess it goes to their, the reliability of their perceptions.
And there's also a comment here about men not, parents were telling the CPS investigator that no men should be allowed to work in the day.
Correct.
Why are you reporting that?
This was, well, I'm reporting it because in the complaint, I think it was in the complaint where they said that they had reported to OELC that they thought that Eli Tabor was creepy. And based on what I saw in the CPS file, the law enforcement file, and my interviews with OELC employees, I didn't think that that was true. And I put there in the CPS file, they said that no men should be allowed to work in a daycare with small children. What I got from the OELC interviews was that their objection to Eli Tabor was a little different from that. It was not just that he was a man, that he was also effeminate and gay.
Okay. And what, as a result of that, I think you justified this morning that he was moved out of that class. She was moved out of that class.
That's what I heard in the OELC interviews, and I may have seen that in the CPS investigation file too.
Okay. And then we'll move further. Now we're on SRD. Can't read through the block. I'm trying to remember who it is. Again, you're reporting that Eli Nelson was the teacher, not Eli Tabor. And down below, there's no evidence that Eli Tabor had any contact with the SRD at any time near in time to the statement of it, that she was alleging or had reported to her parents that somebody had touched it.
I actually, but I don't know if she has a father. I know she has a mother, and what she allegedly said was Eli Pee Howie.
Okay. This is where we're not sure which Eli she's talking about, but the Eli that's a teacher is the other Eli, baby Eli, Eli Nelson. Right?
Yes.
Okay, let's go down. The CPS investigation there, you're reporting is that the polygraph test, baby Eli, and he passed the test, and they closed the investigation.
Yes.
And go down to SA, and we talked a lot about SA. Here you're reporting that his mother, a single mother with 2 children, with issues of drug addiction and history of abuse and boys and crime. What's the relevance of that to your evaluation?
It's potentially relevant for liability and damages. And with respect to liability, and I mean, the issue with respect to Ms. Myrick, and I told you that this was tricky, that when she reported Eli Tabor, she said, and this is also included in the Sue Batson report, I have suspected that he was doing this for a long time. And that's relevant to liability, you know, in that event that the jury wants to assign fault to her, either formally on a verdict form or informally in their deliberations. It's also relevant to damages, because, you know, if you have a parent who suffers from drug addiction or brings abusive people into the house, then there is an issue of, you know, if the child is, you know, has mental illness or dysfunction as a result, what is it caused by? And so that's up to the jury to assess, you know, is this emotional distress caused by the sexual abuse, or is this emotional distress caused by, you know, conditions in the home unrelated to the sexual abuse, such as a drug addicted mother or a history of, you know, abusive boyfriends, you know, living in or visiting the house. So,
Would you consider that a mitigating factor in the damages on liability points of the year defense?
yes, it could be.
Going down? Let's keep it. And you summarize, in some employees at the West Site noticed their claims that there was something wrong with the relationship between Tabor and SA. And many of the teachers claim they reported concerns to Ms. Orgdahl that she denies, paraphrasing, and she had no desire. But you believe that Ms. Orgdahl had no desire or incentive to protect people. That go to, well, let me just ask, why is that wrong?
It's really not.
Right.
whether I believe Rose Orgdahl or not is probably not relevant. You know, the allegations exist, and they would be made. They were made to CPS. They would be made at trial that these complaints were made, and that's really what the jury is going to focus on. But I'm basically doing some speculation here as to which I've seen in other cases as well, where, you know, after the molestation is revealed, you know, people basically see clearly what was before them, but that they really didn't know or really understand at the time. That there may have been red flags that, you know, given that most of these teachers were good friends of Eli Tabor up to the time he was arrested. And I can't believe that they would have been good friends with him if they suspected that he was molesting a 5-year-old boy. So again, this is all just kind of psychological gobbledygook for me. But what I wanted them to know is that these teachers have said these things about Rose that are going to be problematic for liability in the SA case.
You know what hindsight bias is?
Yes.
What is that?
Well, it's just that I guess you see more clearly in hindsight after you realize how something turns out.
Okay, thank you. Let's continue to scroll down. AK they're reporting that the mother came forward with a claim after she heard that Eli was arrested. Right?
Yes.
We've already talked about that. And also right here, there were no allegations of inappropriate touching. But you're talking about allegations by the parents, by the child.
That, I mean, a better word to use is, at the time that she initially came forward, there were no disclosures of inappropriate touching.
Okay. Were there later disclosures of inappropriate touching?
Yes.
Were they credible?
Well, CPS considered them not to be credible because they only occurred after they told Ms. Bond, this is the kind of thing that we need in order to, you know, investigate further if there was sexual abuse.
Okay. There's some defiant and unmoved behavior behavior mentioned here. If that's all you have, is that enough to find abuse?
Typically no, because they're, when you've got a toddler or somebody up to the, age of 5, they can engage in defiant and unruly behavior for a variety of reasons.
Okay. And then CPS considered Mr. Bond to be not credible, incredible, and did not consider his son to be a victim of abuse by Tabor. Is that after he had confessed?
I'm sorry.
Is that after his confession?
After Eli Tabor's?
Yeah.
Yes.
Okay. Then you're reporting, but you're reporting here that you have just initiated discovery into this claim. Why? If you remember.
I don't.
And claims he was molested by Tabor and just initiated discovery into the
I'm sorry. I can't do it that.
I'm sorry. MM claims that he was molested by Tabor. They have just initiated discovery into this claim.
I would, yeah, at this point, I don't think that I had received answers to written discovery served on him, and didn't have any idea what the complaint was based on. And as I said, I thought that the complaint, the JJ complaint, might not have even had allegations that they were sexually abused. So I remember checking to see, have there been any law enforcement complaints? Does OELC have any complaints about this, and not coming up with anything? So that's why I answered that as I did.
Okay, going down, JJ, plaintiff's counsel stated he was. Plaintiff's counsel has stated that he has been detained by JJ and his mother. She claims of sexual abuse against Tabor. He has not yet filed a separate complaint for Salt Lake for amending a complaint to add these things. It's one of the reasons why you were just, well, that was another person. So there are no reports to CPS or to law enforcement of any inappropriate contact by Tabor against JJ. There are no reports to OELC of any allegations of abuse by Tabor. Discovery has revealed that Tabor once gave a ride to JJ to a doctor's appointment. The claim brought by JJ based solely on this one time that Tabor was along with JJ in the ride to a doctor's appointment.
It might be, and the reason I say that is when I say discovery has revealed, I might mean that rather than formal discovery pursuant to the civil rules, it might mean that when I interviewed people at OELC, they told me that, I said, like, tell me about JJ and any potential connections, and somebody may have told me that we do remember him giving a ride to JJ to a doctor's appointment. So if there were more rides than that one, I don't know about them today. And if I knew about them then, I don't remember that today, what the details are.
Okay, let's scroll down. We've already talked about SA and significant risk of liability. Keep going. Keep going down. Here you're talking about plaintiff's counsel's focus in the case is a bit off the mark rather than focusing on what the teachers observed in the relationship between Tabor and SA. What they did in response to plaintiff's counsel appears to be focused on other issues like the hiring process or the changes instituted after the 2 allegations against one or both. Let's go back further down. One or both of the PLIs made in 2009. Why was that important to your analysis of liability?
Well, I did not think that their focus would remain on that. I thought at some point they're going to, interview witnesses and get the investigation file and see that there is a much stronger liability case to be made here with respect to these red flags, not on whether, OELC did a psychosexual interview of Eli Tabor before they hired him. So I'm saying that based on the complaints, I think, that I originally received, their focus seemed to be, on the hiring process or on, what happened after the JS or SRB complaints.
Mhm.
But I think I predicted that at some point, the focus was going to be on something that's going to be much more troubling on a liability front.
Okay, that was the point of the comment, to say that we've got more problems than they may know. And they may not know about everything right now. Okay.
Yeah, based on when the complaints were filed, I thought that there's going to be more here revealed that's going to be more problematic than, if the case was all about, did you ask Eli Tabor during his interview whether he'd ever been sexually abused as a child? That I thought, that states a very weak case for liability. If you focus on, what teachers had seen, that gave them cause for concern, then you have a very troubling case for liability.
Okay, let's keep going down. And that's what you're saying there in that first paragraph.
Right. That things are going to get a lot more problematic on a liability standpoint soon.
Okay, and then you go through some challenges in proving liabilities that plaintiffs would have, and just kind of take a quick look at this. The CPS investigated the allegations and let me start over. CPS investigated the allegations and concluded that they were unfounded. Tabor was not known to have any contact with either child in the time period of the allegations. We're talking about JS and SRB, I think.
Right, the two girls.
And two girls. And Tabor was not known to have any interest in either child at any time. Eli Nelson, however, was the teacher in both the girls' classrooms. Is this part of your evaluation on liability?
Yes.
Okay.
So I'm just going to let you know that a number of times when we're reading, I'm just writing in the syllable now.
I'll try to slow down.
Speak up. That's the biggest thing.
Let's keep going down. We're going to run out of time here. Let's keep going. Okay. So here's where you're starting to put some numbers on paper, correct?
Yes.
Okay, and you mentioned here that plaintiff's counsel believes the limits are $4 million, correct?
Correct.
And you're writing back, well, I'm not an insurance coverage attorney. I do not understand how Mr. Cochran is speaking to policy limits. And then you go on, I do not see these 6 claims taken together having a settlement value at or near the amount he is willing to accept. And then you go on in the next paragraph to say, I can justify a settlement of the SA case in the range of $1 million, and the other 5 claims are worth substantially less given the lack of corroborating evidence that Tabor had any contact, much less sexually inappropriate contact with any of these children And so there was one very substantial claim and 5 nuisance claims. Let's keep it going down.
Right, Your Honor. You just, I mean, it reads into the record, but there's no question.
Yeah, I'm gonna ask. So at the time that you wrote this letter, what kind of values were you thinking about for the other 5 claims?
Probably $50,000, $30,000 to $50,000.
What's the basis?
The fact that there is a lack of corroborating evidence that Eli Tabor had sexual contact with them. I thought that the other 5 claims all had issues, whether they were victims or not.
Okay. And why did you put $1 million value on the SA claim? Where did you come up with that?
At the time, I thought was a very substantial settlement for a sex abuse claim. I think that a lot of claims were going for about half that amount during this time frame.
Why do you say that?
Well, being part of the business, settling cases myself, and also sharing information with other attorneys who were settling cases. Particularly the mother load of cases was against the Archdiocese of Seattle, and we would share settlement amounts just to. Because Mike Patterson wanted to make sure that our settlements were not going to be, the Diocese of Yakima were not going to be impinging on his.
I'm sorry.
Let's stop. Let's stop. See you tomorrow morning at 9 o'clock.
Okay.
Oh.
Steve, are we okay to leave these in here? We leave our stuff in here.
I don't, because we're here tomorrow, so. I won't leave anything valuable.
Okay.
I can move myself, I can't move the computer, so I would consider that. I considered that. I couldn't make up my mind, but I like to take this. Every several times to get my ears off, so. Yes, I agree.
I mean, like, because everybody's listening that way, in addition to this. Just an idea.
No, I agree. I think I'll try that tomorrow.
Yeah, we're back there.
Well, I speak up most of the time.
Did we get an answer that we study here about
Yeah. Yes, if you're interested, it was.
the last report?
A lot, yeah.
Right. What about this?
So you're gonna know I'm comfortable enough, I'm leaving my writer here.
No, I got the joke.
Hey,
One point.
Enough to scare you.